We continue now with reaction to the Constitutional Court ruling in the Ramaphosa versus Mkhwebane case, and I'm now joined by Muntu Sithole. He is Manager of Legal Services at the Office of the Public Protector. Mr. Sithole, a very good afternoon to you and welcome to the Daytime Update. Your reaction as the Office of the Public Protector on this ruling that has been unfavorable to you?
Afternoon, Tammy. Obviously we were expecting a positive outcome from the ConCourt, and from your previous discussion, it's clear that the issues that were before the ConCourt were constitutional issues which required the ConCourt to actually stamp authority on those issues. This investigation by the public protector, Tammy, is essentially an investigation about accountability of the executive. It's in the same vein as the investigation that was conducted by the former public protector on the Nkandla matter. It's essentially about accountability and openness. And that's all essentially what this investigation was about. And the ConCourt had an opportunity to say, how do we make sure that the executive is accountable? You will remember that these issues arise from the time when the president was the deputy president of the country. They don't necessarily arise now when he was president. And therefore, there is that bridge or the gap in between him being deputy president and receiving funding for his campaign to be the president. So essentially, that's what this whole issue is about. And unfortunately, the Constitutional Court did not find in our favor, although we are glad to note that Mogoeng CJ actually was with us on the crux of the issues that we forwarded with the Constitutional Court.
So what then do you, as the Office of the Public Protector, propose as a possible way forward in the sense that, as you said, Chief Justice Mogoeng was in accordance with you, saying that the crux of this particular issue is about mechanisms that need to be put in place in order to hold the executive accountable. If the public protector in this particular instance is not a suitable vehicle for that to happen, what are the propositions of a way forward?
Well, unfortunately for us, Tammy, there wouldn't be any way forward because this is the judgment of the Constitutional Court. So in terms of, as far as the public protector is concerned, we have reached the ceiling in terms of which we needed the view of the court or the authority of the court on accountability of the executive. Therefore, the only thing we can take from the judgment is those issues that we believe we probably did not get right. Obviously, we have not had the opportunity to read the entire judgment. But unfortunately, for now, there's nothing we can do going forward. We'll probably still get more complaints about executive members' conduct, but the judgment will actually be sitting on the face of the investigation. Members of the executive will actually use the judgment as a ticket to say, look, you can't get involved in matters that are interlinked between my private issues and my public issues, because here these issues were interlinked. That's why the public protector received the complaint, Tammy. So unfortunately, we have reached the end because this judgment cannot be appealed, even if we had wanted to.
What impact does this particular judgment have on the confidence of the public protector and the public protector's office to continue conducting investigations that are often negatively then construed by the courts, and you are getting to negative reviews around the judgments that are being made? Does that in any way impact the confidence of the office in moving forward and conducting even the other investigations and making the rulings that you do and the recommendations?
Yes, partly it does, Tammy, to the extent that you wish the court has actually found in your favor in one aspect, which aspect is important to your mandate specifically on the executive members' ethics code. It's a very important instrument through which the public protector may investigate the complaint that she receives. So when you get a judgment that says actually you went beyond the scopes of the Executive Members Ethics Act, that kind of now may limit your appetite of proceeding to investigate EMEA matters, especially where matters where the executive's interest has a risk of being in conflict with their private and public interest. Therefore, to that extent, it does, but to a larger extent, it actually says you really needed to come to court to get clarity from the court. I mean, the issues of the application of the Executive Members Ethics Act is the main crux of the judgment. And you have Mkhwebane who is with us on the interpretation of that statute, and you have the majority that's not with us. So the dispute on the interpretation of the law was genuine. And therefore, going forward then, because the majority judgment is the one that's binding, it will obviously guide us on dealing with complaints in respect of Executive Members Ethics Act.
We'll leave it at that, Mr. Sithole, for this afternoon. Thank you very much for your time. That's Mr. Muntu Sithole. He's the Manager of Legal Services at the Offices of the Public Protector.